Hello, my name is Oana Ștefan. Welcome to your second EU Law online seminar. Today, I will give you a brief introduction to free movement of goods, in particular to Article 34 TFEU. We will start with a brief introduction to the EU internal market, which is a single market in which the free movement of goods, services, capital, and persons is assured, and in which citizens are free to live, work, study, and do business. The internal market comprises of four basic freedoms. There is first the free movement of goods, which will be the topic of this seminar. Second, free movement of services consists of the cross-border provision of services, such as broadcasting, advertising, or insurance. Third, free movement of persons includes free movement of workers, or the right of EU citizens to seek employment and work in another member state. As an example, based on this right, UEFA had to alter the rules for the transfer of players. There is also freedom of establishment, which entails the freedom of European citizens to set up businesses in another member state. Finally, the European Union treaties provide also for free movement of capital. In practical terms, the EU internal market is the largest market in the world. It is the EU's greatest achievement. It has 10 trillion euro in annual value, gathers 500 million consumers. However, the crisis had a huge impact with the shrinking of EU economy. Over the last 10 years, the internal market has created an additional growth of 1.8%, has created 2.77 million additional jobs, and increased the trade between member states by 15% per year. Before delving into free movement of goods, it is important to have a brief look of the different economic integration types. First, there are the free trade areas. Within this type of economic integration, the member states should remove all impediments to free movement of goods among themselves. But each state retains the autonomy to regulate its trading relations with non-member state. An example for this is NAFTA. Another type of economic integration is the customs union. This entails a free trade area and a common external policy in respect of non-member state. An example for this would be Mercosur. Common markets entail customs union and free movement of persons, services, and capital. An example for this is EFTA. The monetary unions entail a common market and a single currency. An example for this would be the Economic Community of Central African States. Economic unions entail a monetary union and a single monetary and fiscal policy. The example for this would be the European Union. Finally, we might envisage a complete economic and political integration, whereas foreign security policies, security and tax are unified within a central authority. However, this has not yet been achieved anywhere in the world. Getting back to the internal market, the question is, how is it achieved? There are two basic models that have been employed so far in European integration: the decentralized and the centralized model. The decentralized model is based on the principle of non-discrimination. It means to treat the like in a like manner and the unlike in an unlike manner. It includes both direct and indirect discrimination. Also, it relates to the concept of free market access, which is a common principle for the four freedoms. The free market access principle means basically that what is lawfully produced, educated, or delivered in a member state should have free and unrestricted access to the market in another member state. This entails mutual recognition subject to mandatory requirements. The decentralized model is based on court rulings and accounts for around 25% of EU trade. It is a model of negative integration, which implies the elimination of barriers that restrict the movement of goods, services, and factors of production. Hence, it is a model essentially deregulatory. implying the elimination of legislation that would constitute a barrier to free movement. It is a model that helps promoting regulatory competition, whereby lawmakers might be enticed to compete with one another in the kinds of law offered in order to attract businesses, traders, service providers, or workers to operate in their jurisdiction. The centralized model, on the other hand, is based on statutory measures. It is a system whereby a common set of rules is established which apply to a broad class of transactions. Currently, the centralized model covers around 70% of EU trade. It relies on positive integration, that is to say, the creation of a common sovereignty through the modification of existing institutions and creation of new ones. Hence, the centralized model is essentially regulatory, and it involves a series of directives or regulations being passed by the European institutions with a view to achieve harmonization of legislation. What is important to understand here is that uniformity is not the goal. Rather, harmonization can be represented as a continuum ranging from uniformity to flexible harmonization. Harmonization of standards can also be delegated to bodies such as the European Committee for Standardization, or CEN, the European Committee for Electrotechnical Standardization, or CENLEC, or the European Telecommunication Standards Institute, or the ETSI. Furthermore, the harmonization is based on information sharing, with states being compelled to notify the Commission if they introduce new technical standards. The topic of the seminar today is free movement of goods. There are several ways in which free movement of goods can be impeded. Let's take the example of a product, say beer. A member state can restrict trade in beer by imposing a high customs duty or by imposing discriminatory taxation, for instance, beer higher than wine. They can restrict the quantity of beer that can be imported, or they can impose regulatory barriers. In Germany, for instance, a bill required beer to contain only certain ingredients, with no additives being allowed. This impeded the access to the German market of foreign beers that included those additives. So our outline for today is, first, we're going to have an introduction to the provisions on free movement of goods. And then we were going to look into these provisions more in depth. In particular, we're going to discuss briefly fiscal barriers, such as customs duties and charges, and internal taxation, and we will then focus on non-fiscal measures. Most of the session today will deal with quantitative restrictions and measures having equivalent effect to quantitative restrictions. I will only briefly deal with justifications, and I will invite you to study those independently. First, the introduction. With regards to the scope of the treaty articles dealing with free movement of goods, we have to remember that the product must be considered a good. According to the Art Treasures case, goods are products which can be valued in money and which are capable as such of forming the subject of commercial transactions. Basically, anything that can be bought or sold. Then, the good must be used in cross-border trade between member states. The good must cross a border in order to engage the treaty provisions dealing with free movement of goods. Third, the person to whom the provision is being applied must be an addressee of the treaty, which means a member state or an institution. But how to achieve free movement of goods? A first step is to set up a customs union, internal and external. This is all done. The second step is to remove non-fiscal obstacles. And this is a point a bit more problematic on which we will focus our attention today. Starting now with fiscal barriers, I will briefly deal with customs duties and charges and internal taxation. This is just a very, very brief introduction to fiscal barriers. As I mentioned, the focus of today's lesson is on Article 34 and quantitative restrictions and measures having equivalent effect to quantitative restriction. So, the removal of fiscal barriers is obviously crucial for achieving free movement of goods. First, all customs duties and charges need to be eliminated. Second, taxes should not be imposed in such a way as to impede free movement of goods. Article 30 TFEU provides for the removal of customs duties and charges, otherwise known as fiscal barriers. It states that customs duties on imports and exports and charges having equivalent effect shall be prohibited between member states. This prohibition shall also apply to customs duties of a fiscal nature. Customs duties on imports and exports are pretty straightforward. The notion of charges having equivalent effect needed to be defined by the court, and this happened in the statistical levy case. According to statistical levy, any pecuniary charge, however small, and whatever its designation and mode of application, which is imposed unilaterally on goods by reason of the fact that they cross a frontier, even if it is not imposed for the benefit of state, constitute a charge having equivalent effect to a customs duty. The second fiscal barrier that needs to be eliminated relates to internal taxation. Now, internal taxation can constitute a fiscal barrier to free movement of goods. However, with regards to internal taxation, the principle is that member states lead an autonomous taxation policy. We cannot, therefore, remove all tax between the member states. This would be impossible. However, Article 110 of the TFEU provides for certain rules in that regard. It states that no member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess to that imposed directly or indirectly on similar domestic products. Furthermore, no member state shall impose on the products of other member states any internal taxation of such a nature as to afford indirect protection to other products. These two paragraphs might seem confusingly similar. However, the difference between the two is quite important. While the first paragraph deals with similar products, the second paragraph deals with other products. While the first paragraph prohibits internal taxation in excess, the second prohibits indirect protection through tax. Let's see how did the ECJ deal with these two aspects of internal taxation rules. For paragraph 1 of Article 110 and the notion of similar products, we can take as an example case 106/84, Commission versus Denmark. Denmark was taxing wine made from grapes at a higher rate than wine made from other fruit. The question was whether wine made from grapes was similar with wine made from other fruit. The court looked at the objective characteristics of goods, such as the origin, method of manufacture, organoleptic properties, such as taste, alcohol content. Also, they considered whether or not goods made the same need from the point of view of the consumers. The conclusion was that these are similar products, and therefore Denmark had to equalize taxation. Part 2 of Article 110 deals with goods in competition. For this, we can take as an example the beer and wine case. The Commission argued that British tax law contravened Article 110 TFEU as, if judged by equal volume, wine was subject to a tax burden approximately 5 times higher than that imposed on beer. The court had to determine whether wine and beer belonged to the same category of alcoholic beverages, and if there was competition between these two products. The court noted that products were substitutable, as they both were product of natural fermentation, and were used as thirst-quenching drinks or to accompany meals. However, wine and beer are different. Alcohol content of wine is 4 times that of beer. Wine and beer are produced according to different processes. They are consumed also in different circumstances. With regards to whether these goods were in competition, it looked like people in England would not necessarily substitute beer for wine. And the court reached the conclusion that this was precisely because of the taxation system. Indeed, since the tax on beer was lower than the tax on wine in the UK, consumers could buy more beer for their money than wine. Therefore, the taxation system was orienting consumers' habits and was stamping wine with the hallmarks of a luxury product, which can scarcely constitute, in the eyes of the consumer, a genuine alternative to the typical domestically produced beverage. The court decided that wine and beer were indeed in competition, because wine was subject to a 100 tax burden by reference to alcoholic strength and 400% by reference to volume. In comparison to beer, the taxation system breached Article 110, paragraph 2. Now the question is, what could the UK do about it? The UK should not equalize tax as they should have done if we were in a 110 paragraph 1 scenario, but lower the tax on wine and increase the tax on beer. After changing this legislation, it emerged that the court was right. The people in the UK started indeed to consume more wine. In more recent cases, the court approached matters in a more sophisticated way, while asking for more rigor in market analysis. Therefore, the burden of proof on the Commission is quite high to show that actually goods are in competition and to also show the existence of protective effect. See, for instance, case C16705, Commission versus Sweden. If fiscal measures relate in a way or another with a certain sum of money that the traders need to pay in order to be able to sell their products in another country, non-fiscal measures deal with regulation that impedes free movement. These are detailed in Article 34-36 TFEU. Article 34 deals with imports, Article 35 with exports, which follow roughly similar pattern as imports, so our focus will be Article 34 today. And finally, Article 36, which deals with the exemptions to the prohibitions provided for in Articles 34 and 35. Now, starting with Article 34, it says that quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. What are, first, quantitative restrictions? Quantitative restrictions are non-tariff quotas limiting the quantity of goods coming into a state or leaving a state, or, as defined in the case of JEDO, measures which amount to a total or partial restraint of, according to the circumstances, imports, exports, or goods in transit. Most extreme forms are the bans, as in Hen and Darby, who are banned from importing pornographic articles in the United Kingdom. If quantitative restrictions can be defined in a straightforward way, a vast body of the case law of the court dealt with measures having equivalent effect to quantitative restrictions. Several cases are crucial in this regard. These are Dassonville, Cassis de Dijon, Keck, and Trailers. The remainder of the seminar will trace the evolution of the case law on free movement of goods by looking at these landmark cases and their spin-offs. Starting with Dassonville. This case is important because it defined measures having equivalent effect to quantitative restrictions. The case concerned Belgian legislation requiring from importers to present certificates for goods bearing the designation of origin. These certificates were easy to obtain if one was importing the goods directly from the country of origin. However, Dassonville imported Scotch whisky from France into Belgium. Thus, the whisky was already in circulation within the internal market, and it would have been very difficult for Dassonville to obtain the certificate of origin from Scotland. Dassonville was prosecuted, and he argued that Belgian law was a measure having equivalent effect to quantitative restrictions. In its preliminary ruling, the European Court of Justice had the opportunity to define measures having equivalent effect to quantitative restrictions as all trading rules enacted by member states capable of hindering, directly or indirectly, actually or potentially, intra-community trade. Now, this is a very broad definition, which could include even pub opening times, for instance. This broad formula brought an enormous amount of cases to the court. Later on, it was reformulated in KEC. There are two important aspects that you need to remember in relation to the Dassonville case. First, the crucial element in proving measures having equivalent effect to quantitative restriction is the effect. The discriminatory intent is not required. Second, any kind of regulatory measures will be covered by Article 34. The case has been considered by some authors as the basis of the economic constitution for the European Union and the emergence of a constitutionally protected right for individuals to engage in market transactions. Other authors have considered, on the other hand, that this case might lead to an economic government by judges, with collective interests being overlooked in the process. In other words, these authors argue that markets cannot be separated from the social context in which they operate. Law should be not about protecting market rights, but about mediating between plural societal interests. This controversy is very important and emerges in all cases that we are going to discuss. In order for the economic supranationalism to be meaningful, the interpretation of Article 34 should achieve the right balance between market liberalizing norms and national sovereignty. The necessity for achieving such balance was noted by the court in paragraph 6 of Dassonville, which referred to a rule of reason. In the words of the court, in the absence of a community system guaranteeing for consumers the authenticity of a product's designation of origin, if a member state takes measures to prevent unfair practices in this connection, it is, however, subject to the condition that these measures should be reasonable and that the means of proof required should not act as a hindrance to trade between member states and should in consequence be accessible to all community nationals. In other words, if a measure breaches Article 34, it does not mean that automatically it needs to be removed from the legislation. States might be able to justify restrictions to trade by reference to Article 36 TFEU. We will now come back to the Dassonville definition and see how it was used by the court in subsequent cases. For this, we need to deconstruct the definition and discuss its various elements. First, the notion of trading rules. This referred to the marketing stage, not the production stage. There is a broad understanding of such measures, which include governmental practices or policies, as for example in the Buy Irish case. In this case, the government sought to promote the sales of Irish goods, while suggesting various measures for this: an information service, exhibitions, affixing a Buy Irish symbol on certain goods, and a publicity campaign led by the Goods Council in favor of Irish products. There was no binding measures, which was challenged here. But the court considered that the campaign in itself, as rubber stamped by the government, breached Article 34. This was because its purpose was to substitute imported products with domestic products on the Irish market, and thereby to check the flow of imports from other member states. Article 34 applies also to the failure of the state to take measures necessary to prevent disruptions to free movement of goods by individuals. This is the Spanish strawberries case. In this case, the French police did nothing to stop various violent attacks by French farmers against products from other states. In the words of the court, the fact that a member state abstains from taking action or, as the case may be, fails to adopt adequate measures to prevent obstacles to free movement of goods that are created in particular by actions by private individuals on its territory, aimed at products originating in other member states, is just as likely to obstruct intra-community trade as is a positive act. As we have seen in the previous seminar on direct effect, the notion of state has a wide meaning in European Union law. Within the ambit of Dassonville definition, it can include the central government, such as in the Dassonville case, quasi-governmental bodies, such as the Goods Council in the Buy Irish case, or professional bodies, such as in the case of API. However, one thing to remember is that Article 34 has only vertical direct effect, as it is addressed to states only. Things are not completely clear in this regard, because, as we have seen in the Spanish strawberries case, the state is somehow responsible also for acts of individuals. Another element of the Dassonville definition is that Article 34 prohibits measures which are capable of hindering, actually or potentially, intra-community trade. This means that a measure having a potentially disrupting effect on interstate trade will breach Article 34. The consequence to this is that there is no de minimis rule to Article 34. It does not matter that the measure concerns a very small part of the territory of one state. In the case of Blume, a Danish decree prohibited the keeping on the Lesso Island of certain nectar-gathering bees other than those of the subspecies Apis mellifera mellifera. Bloom was being prosecuted for keeping on Lesso bees other than those of the subspecies Apis mellifera mellifera. Now, the island of Lesso consists of only 0.3% of the Danish territory. The measure constituted, however, a measure having equivalent effect to a quantitative restriction, and it breached Article 34. Denmark managed, however, to justify the measure under Article 36 TFEU, as it was taken in order to prevent the disappearances of certain species. Second, it does not matter that a good is produced in very small quantities in another member state, such as in the foie gras case. This case concerned French rules on the composition of foie gras, even though very, very few foie gras was produced at the time outside France. However, purely internal situations, or situations that are too remote from trade between member states, are not covered by Article 34. In Peralta, an Italian national repeatedly ordered the discharge into the sea of water which have been used to flush tanks, which had previously contained caustic soda at the time when the vessel was outside the limit of Italian territorial waters. This was prohibited by Italian legislation, and Mr. Peralta was prosecuted. He argued that the Italian legislation was against Article 34. This was because it required Italian vessels to carry costly equipment, hence restricting their activity and ultimately free movement of goods. The court noted that Italian legislation made no distinction whatsoever according to the origin of substances transported. The purpose of Italian legislation was not to regulate trading goods with other member states. Thus, the restrictive effects which it might have on the free movement of goods were too uncertain and indirect for the obligation which it laid down to be regarded as being of a nature to hinder trade between member states. With regards to the hindrance on trade, we can distinguish two types of measures that can be considered measures to having equivalent effect to quantitative restrictions. These are the distinctly applicable measures, where a measure discriminates in law and in fact between domestic and imported products, and the indistinctly applicable measures. Those measures that apply indistinctly to domestic and imported products, but in fact make importations more difficult. Examples of distinctly applicable measures include imposing supplementary inspections on imports, such as in the case of the San Jose insect. Also, promoting national products might constitute a distinctly applicable measure. An example for this is organizing an official campaign, such as in Buy Irish. Or, in another Irish case concerning souvenirs, all imported but not domestic jewelry depicting motifs suggesting that they were souvenirs of Ireland had to bear indication of the country of origin. The court considered that souvenirs were pictorial reminders of the places visited and did not have to be manufactured in the country of origin. Therefore, indicating the country of origin on this type of products constituted a distinctly applicable measure that was discriminating against foreign products. In relation to indications of origin, these are lawful only where the product genuinely has distinguishing qualities and characteristics which are due to the fact that it originated in a special geographic area. With regards to the indistinctly applicable measures, the landmark case is Cassis de Dijon. This is the second crucial case you would need to remember in relation with Article 34. Also, this is yet another step taken by the court towards achieving economic supranationalism. Cassis de Dijon is a blackcurrant fruit liqueur made in France, which, as a side remark, is an essential ingredient in any Kir Royale cocktail. German authorities refused to allow this liqueur to be sold in Germany, owing to its insufficient alcoholic strength. The minimum alcoholic tenure tolerated in Germany was 25%, whereas Cassis de Dijon ranges between 15 and 20%. As you can imagine, there was no discrimination or protectionism here. The 25% rule applied to all alcohol, no matter if it was domestically produced or not. In the preliminary ruling it issued in this case, the ECJ famously decided that there is no valid reason why, provided that they have been lawfully produced and marketed in one of the member states, alcoholic beverages should not be introduced into another member state. This principle is known as the principle of mutual recognition. According to Cassis, goods lawfully produced and marketed in one member state can in principle be sold in another member state without further restriction. Mutual recognition is meant to replace dual regulation of a product. It also introduces the principle of home state control, enabling national legislation to have extraterritorial effect. To come back to negative integration, as discussed at the beginning of this session, Cassis is the epitome of the regulation. Member states should simply disregard national rules and standards and recognize foreign legislation. However, this begs the question, should member states always recognize foreign standards and rules? As we have seen a few slides back, member states could justify certain restrictions to free movement of goods by relying on Article 36 TFEU. Cassis adds to that list some other justifications, called mandatory requirements. Mandatory requirements are justifications that member states can use in order to introduce restrictions to free movement of goods. There are two important distinctions between mandatory requirements and Article 36 list of justifications. First, Article 36 constitutes a closed list of justifications. Member states cannot add to that list. Mandatory requirements constitute an open list of justifications. Second, mandatory requirements apply in principle to non-discriminatory restrictions. The court accepts most of the mandatory requirements put forward by the member states, provided that the national policies do not pursue aims of a purely economic nature. The list shows a recognition by the EU of non-commercial values. On the other hand, discriminatory rules are much more serious than indistinctly applicable rules. Discriminatory rules strike at the very heart of the community, and hence any possible justifications should be narrowly confined within the limits of Article 36. Nevertheless, the rule that mandatory requirements should not be used in order to justify discriminatory measures has come under increasing strain during the last years. This is because Article 36 presents a very limited list of justifications and does not include important reasons to restrict free movement of goods, such as, for instance, the protection of the environment. It is sometimes argued that Article 36 does not keep pace with the fast evolution of society and the law. Finally, it is not always easy to distinguish between cases involving distinctly and not distinctly applicable rules. We will come back to this point briefly when we will be discussing justifications. To sum up, the contribution of Cassis de Dijon to European integration relies on two important new principles: mutual recognition and mandatory requirements. It is important to take one moment now to reflect on how a free movement of goods case could be solved following the Dassonville-Cassis line of case law. If the measure falls under Dassonville-Cassis, it means that it constitutes a measure having equivalent effect to quantitative restrictions, and hence it is a breach to Article 34. However, the measure can be justified under Article 36 or through mandatory requirements. Cassis replaces dual regulation, that is the regulation of the home and of the host member state, by only one set of rules, those of the home member state. However, mutual recognition can be a problematic principle. This is because it might promote excessive deregulation and hence entail a race to the bottom. For example, business might move to countries where standards and requirements are the lowest, which will drain investment from other countries, determining loss of jobs in certain parts of Europe. This will entice business to lobby their governments to reduce standards, and finally, the lowest standards would prevail. However, economic integration showed over the years that we should not fear deregulation that much. The development of the European market integration confronted, at the very beginning, the dead wood of centuries of regulatory tradition in all member states. Regulatory renovation was thus welcome. Furthermore, a race to the bottom did not happen. The case of Glocken, case 407/85, is telling in this regard. This is a case where Italy insisted that only pasta made from durum wheat could be sold in Italy and not pasta made from the cheaper common wheat. The court pointed out that trends in the export markets demonstrated that competition based on quality operates in favor of durum wheat. And therefore, we do not always have a race to the bottom. However, the wide definition of measures having equivalent effect to quantitative restrictions in Dassonville, coupled with the principle of mutual recognition, might entice litigants to make abusive use of EU law. A UK case is telling in this regard, reference 2007 UK HL 52. The Countryside Alliance challenged the ban on fox hunting in the UK on the grounds that it restricted free movement of goods and services. For example, they argued, among others, that the ban restricted cross-border trade in hunters and greyhounds, that would be necessary for fox hunting, and that it also restricted free provision of services such as hiring and livery services and hunting-based holidays. Rightfully, the National Court decided in this case that the ban on fox hunting did not engage Article 34 TFEU. However, this gives you an idea as to how far claimants can go in their arguments based on the free movement provisions of the treaty. Finally, abusive reliance on Article 34 can trigger unclear case law of the European Court, as illustrated by several judgments that followed. We will now have a brief look at this. Cassis applies to rules that regulate products themselves. Examples include the Belgian law requiring margarine to be marketed in cube-shaped packages, such as the case of Rau, or the German fair trade law, which was at stake in Clinique and Mars. In Germany, the name Clinique was considered to mislead consumers into believing that the products had medicinal properties. Similarly, in Mars, it was argued that a publicity campaign offering a 10% free on all Mars packages was contrary to German fair trade law because the plus 10% free flash covered more than a tenth of the total surface of the wrapping. However, both in Clinique and Mars, the European Court of Justice considered that this interpretation of the fair trade law was contrary to free movement of goods. The judgments of the court in Clinique and Mars allowed companies to pursue a European Union-wide strategy. Therefore, a publicity campaign such as the Mars campaign could be implemented anywhere in Europe without needing to alter the package in order to comply with legislation such as the German fair trade law. The question is, however, what to do to rules that relate to sales of product, or what is more, to rules that relate to the way in which products are used. Should these rules also be caught by Article 34? An affirmative answer to the question might determine a serious encroachment on member state competencies, as rules on use or rules related to sales are most likely issued in order to protect certain goals of a non-economic nature and may have no effect on cross-border trade. Let's see some examples. In Öbel, a rule which prohibited the delivery of bakery products to consumers and retailers at night was considered by the court to be outside of the treaty prohibition. The court considered that such rule cannot have the effect of restricting imports or exports between member states, and hence it did not breach Article 34. In Cinetech, conversely, a law banning sales of videos during the first year in which the film was released was caught by Article 34 and had to be justified by the member state. This was despite the suggestion of the Advocate General, who stated that because national rules were not specifically directed at imports, they did not discriminate against imports and gave no protection to domestic producers. So prima facie, they did not breach Article 34. The court agreed, but considered that the system in place in France may create barriers to intra-community trade in videocassettes because of the disparities between the systems operated in different member states and between the conditions for the release of cinematographic works in the cinemas of those states. The now famous Sunday trading saga is another example showing the difficult application of Article 34 to rules related to sales. It emerged that national courts arrived to different solutions when dealing with the same rules. Some of the courts were holding the prohibition on Sunday trading as being against Article 34, whereas others considered that Sunday trading legislation fell outside of the treaty. The ECJ clarified its own case law and noted that the prohibition on Sunday trading was indeed a breach of Article 34. However, it could have been justified as the national rules on the hours of work constituted a legitimate part of economic and social policy, consistent with the objectives of public interest pursued by the treaty. The unclear case law relating to the application of Article 34 to measures related to sales led to another landmark case of the court, which is Keck and Mitoire. Before passing to the next slide, I invite you to pause the presentation and reflect a moment on what do you think the purpose of Article 34 should be. On the one hand, is Article 34 aimed at liberalizing interstate trade, as government would argue? If the answer to this question is yes, It would mean that cases such as Obel or Cinetec or Sunday trading should all escape Article 34, as they do not relate to rules that regulate trade, but to rules that are aimed at protecting social or cultural values. In other words, sovereignty of member states to regulate social or cultural matters should prevail over economic issues. Or, on the other hand, is Article 34 meant to encourage the unhindered pursuit of commerce in the individual member states, as some traders would argue? If the answer to this question is yes, it would mean that traders can go on and challenge any regulation that hinders the pursuit of their commerce. Member states would have to justify any policy choice, even those that are only remotely related to trade. Now for the Keck case. Keck is the third landmark case that we are discussing today. Keck and Mitoir were selling products at a loss in France, in particular Sati coffee and Picon beer. Selling at a loss was prohibited by French legislation, and Keck and Mitoir were prosecuted. They argued that French legislation breached free movement of goods. The court decided in this case to reconsider its own case law in view of the increasing tendency of traders to challenge more and more rules that were limiting their commercial freedom. The court stated that certain selling arrangements do not hinder trade between member states, provided two conditions are met. Please take a moment to read the excerpt from the court judgment on the slide. We will come back to this statement and the conditions in the following slides. For now, it is enough to remember that the court considered that selling arrangements were not likely to prevent access of foreign products to the market or to impede market access more than they impeded access of domestic products. But let's analyze the Keck judgment more in depth. First, Keck distinguishes between two types of indistinctly applicable measures. Paragraph 15 of Keck deals with product rules: designation, form, size, weight, composition, presentation, labeling, or packaging. These are all measures having equivalent effect to quantitative restrictions. If a state adopts a product-related measure, this measure will breach Article 34 unless the state can provide a valid justification, and the measure is proportionate. Paragraph 16 of Keck deals with selling arrangements. These are not measures having equivalent effect to quantitative restrictions, and the state does not need to justify them. Provided that two conditions apply, the measures do not breach Article 34. These conditions are: the measure should apply to all traders, and the measures should affect in the same manner, in law and in fact, the marketing of domestic products and those from other member states. But what are selling arrangements? These rules are not defined in Keck, which is one of the main shortcomings of this judgment. The literature has identified that selling arrangements are rules about who, when, where, and how products can be sold. Selling arrangements appear to restrict the volume of trade but are different from measures having equivalent effect because they are not designed to protect the home market. They don't have the effect of protecting the home market. They are not discriminatory, and they affect the retailer and not the producer or the importer. Coming back to the question regarding the purpose of Article 34, which I asked you to reflect upon, it seems that the court in Keck has adopted the view that Article 34 is meant to liberalize interstate trade. Keck made, in a way, life easier for member states, and it made it easier for them to preserve their sovereignty and pass measures with a social or a cultural aim. But what are the reasons behind Keck? First, the court seems to imply that Keck is a response to the increasing tendency of traders to invoke Article 34 to challenge any rules that would limit their commercial freedom. This might mean that Keck is a response to a too big workload for the court. Second, Keck occurred in a different context than Dassonville. 1993 is the first year of the post-single market deadline, which was the 31st of December 92. There is maturing economic thinking. Harmonization was successful. So there was little need for judicial activism. Third, the court might have been reluctant to deal with matters of a very intrusive nature. For instance, under Article 36 TFEU and the justifications, the court needed to do a balancing between private and public interests. And it might have felt an unease to do this balancing. Finally, with regards to preserving national competencies in KEC, the court made a major contribution to a more limited form of community governance. Indeed, if all measures would have been caught by Article 34, according to the Dassonville case, it meant that the community could take all measures in order to harmonize, even selling arrangements or rules on use. Let's now briefly deal with case law that followed after KEC. KEC dealt only with selling arrangements, which meant that the measure had to be concerned with the way in which the product is sold, as opposed to the characteristics thereof. However, the distinction between these two categories, product rules or selling arrangements, is not always obvious. For example, Familia Press sought to restrain HBV from publishing in Austria a magazine containing crossword puzzles, for which the winning readers should receive prizes. Austrian legislation prohibited publishers from including prize competitions in the papers. The court said that this law bears on the content of the product, as the competition would form a part of the magazine in which it appeared. This was even if the relevant national legislation was directed against a method of sales promotion, essentially. It became obvious soon after KEC that certain selling arrangements could sometimes have greater effect on imported products. This is in particular the case of bans on advertising. Advertising should relate to the ways in which goods are sold and promoted. Hence, rules on advertising would constitute selling arrangements. However, if a foreign trader has little possibility to advertise its products in a new market, it is unlikely that she will be able to penetrate that market. Hence, even if a ban on advertising will apply to all traders in a territory, thus satisfying the first condition of paragraph 16 of KEC, it may happen that it will not affect in the same manner the marketing of domestic products and those from other member states. Such ban on advertising will have the same burden in law, but will have a different burden in fact, thus impeding market access. A good example for this is De Agostini. De Agostini issued a publication called All You Need to Know About Dinosaurs. Now in Sweden, there was a ban on television advertising directed at children under 12. The Swedish Consumer Ombudsman prohibited De Agostini to use in its TV ad the statement, "Every 2 weeks you can collect the parts for a fluorescent dinosaur model and collect the magazines which together form an encyclopedia, all for only 7.50 crowns. However, TV advertising was the only effective form of promotion enabling De Agostini to penetrate the Swedish market, since it had absolutely no other measures to reach children and parents. The court essentially left it to the national court to decide whether the ban affected in the same way, in fact and in law, the marketing of national products and of products from another member state. It noted, however, that if the ban did not affect in the same way foreign and domestic traders, then the measure would breach Article 34 unless justified. In Gourmet, the court considered a total ban on ads for alcoholic drinks. GIP published a magazine entitled Gourmet. Its issue number 4 from 1997 contained 3 pages of advertisements for alcoholic beverages, 1 for red wine and 2 for whiskey. This issue was solely intended for subscribers, and those pages on advertisements did not appear in the edition that was sold in shops. The Consumer Ombudsman applied for an injunction restraining GIP from contributing to the marketing of alcoholic beverages to consumers by means of such advertisement. GIP considered that this was an infringement of free movement of goods and services. They argued that the characteristic of the alcohol market made it harder for foreigners to penetrate the Swedish market, as these characteristics are linked to traditional social practices, local habits, etc. Hence, the second condition of paragraph 16 of KEK was not met. On the other hand, Sweden presented statistics showing an increase in the sale of wines and a decrease in the sales of spirits. The court left the factual analysis to the Swedish National Court. However, it did analyze the evidence presented by the parties and was more convinced by the data produced by GIP, showing the domination of the domestic market by Swedish beer and other national products. Without advertising, it was apparent that foreign products were disadvantaged in Sweden. The court concluded that the ban must be regarded as affecting the marketing of products from other member states more heavily than the marketing of domestic products. And, therefore, the advertisement ban was constituting an obstacle to trade between member states. The measure was thus caught by Article 34 of the treaty. But what have we learned from De Agostini and Gourmet? First of all, that there is a presumption of neutrality with regards to certain selling arrangements. Second, the commercial operator must show that national measure prevents access to the market of another member state. And third, advertising restrictions in general would fall under Article 34. To sum up, why do we care so much about KEK? What you have to remember here is that KEK reverses the burden of proof for selling arrangements. In the case of product rules, it is the member state that needs to show that the measure is justified. In the case of selling arrangements, it is the trader who needs to show first that the two conditions of KEK are not met. Only if the trader manages to prove this will the member state be required to justify its measure. This means that member state sovereignty is preserved in relation with selling arrangements. In principle, if the KEK conditions are met, the member state will not be forced to explain its policy choices. There are several problems with the KEK ruling. First of all, it doesn't mention what cases it is overruling. Second, the formula selling arrangements is inadequate. Compare a ban on the sale of cigarettes by vending machines and a ban on smoking in public places. Both bans reduce consumption, and hence they reduce the volume of sales. However, only the first one, the ban on the sale of cigarettes by vending machine, is a selling arrangement. It was thus argued it is inappropriate to make rigid distinctions between different categories of rules and to apply different tests depending on the category to which particular rules belong. The severity of the restriction imposed by different rules is merely one of degree. Measures affecting selling arrangements may create extremely serious obstacles to imports. For example, a rule permitting certain products to be sold only in a handful of small shops in a member state would be almost as restrictive as an outright ban on importation and marketing. Third, KEK creates uncertainty. It creates excessive formality and it is confined to the facts of a particular case. Fourth, it is difficult to distinguish between the rules relating to selling arrangements and product characteristics. The application of the test is thus difficult for national courts. This complexity results in particular in a tendency on the part of the European Court to refer back the case to the national court and to give the national court the responsibility of ascertaining the character and the scope of the rule in question. Fifth, it had been stated that the Keck test cannot be translated into to the other areas of movement. Sixth, the Keck test ignores the importance of market access, as trading rules might affect equally all traders but still impede market access. Seventh, a non-discrimination test is artificially introduced in relation to selling arrangements. It was argued that the central concern of the treaty provisions on free movement of goods is to prevent unjustified obstacles to trade between member states. If an obstacle to interstate trade exists, it cannot cease to exist simply because an identical obstacle affects domestic trade. We have seen so far how the very wide definition of measures having equivalent effect to quantitative restrictions has been limited in the Keck case. More recent case law has again embraced a more market access logic and went somewhat back to the wide definition of Dassonville. The trailers case concerned rules on using a product. The legislation at stake was the Italian Highway Code. The Commission asked the court to find that by maintaining rules which prohibit motorcycles from towing a trailer, the Italian Republic has failed to fulfill its obligations under Article 34 TFEU. Trailers was therefore about a ban to use a product. This is neither a product rule nor a selling arrangement. The measure applied without regard to the origin of the trailers, but affected only imported goods, because Italian manufacturers did not manufacture trailers to be towed by motorcycles. The court decided that the rule is a measure having an equivalent effect to quantitative restrictions. The Italian law prevented a demand from existing in the market at issue and hindered their importation. The effect of the Italian law was to hinder access to the Italian market for trailers which were specifically designed for motorcycles and were lawfully produced and marketed in member states other than Italy. The measure fell within Article 34 and needed to be objectively justified. Italy succeeded indeed to justify the measure by arguing that it was appropriate and necessary for the purpose of ensuring road safety. The trailers case is important as in its paragraph 37 it clarifies the notion of measures having equivalent effect to quantitative restrictions. A. Measures the object or effect of which is to treat products coming from other member states less favorably. This is the Dassonville case law. B. Measures applied to goods coming from other member states where they are lawfully manufactured and marketed that lay down requirements to be met by such goods, Cassis de Dijon. And C. Any other measure which hinders access of products originated in other member states to the market of a member state. This is a residual catch-all category. It is considered that the trailers case law embraces a market access approach. If before trailers, a free movement of goods case would have needed to discuss whether the measure is distinctly or not distinctly applicable, following trailers, the only question asked is whether the measure hinders trade. Keck might seem to be overruled by trailers, given the catch-all category of paragraph 37, letter C. Any other measure which hinders access of products originating in another member state to the market of a member state. However, the case law of the court is not very clear in this regard. For example, in Scotch whisky, the court did not even discuss Keck in relation to a selling arrangement. After citing Dassonville and trailers, the court decided that Article 34 covered legislation concerning the imposition of a minimum price per unit of alcohol with respect to the retail selling of alcohol drinks in Scotland. The discussion in Scotch whisky focused then on justifications and the proportionality of the measure. Conversely, in Visnapu, the court analyzed whether the conditions of keg were satisfied in relation to a requirement to hold a retail sale license in order to import alcoholic beverages into Finland. It decided, however, that the conditions of keg were not satisfied, and that the measure constituted a restriction to free movement of goods, albeit one that could be justified. I invite you to take a moment and read these two cases, Scotch whisky and Visnapu, as they might assist you in your exam preparation. As a side remark, research has shown that, even though the keg test was discussed in many cases, the circumstances where this test was actually satisfied were extremely rare. In conclusion, while Trailers appears to have overruled keg, we do not yet have a judgment from the ECJ stating expressly and clearly that this is the case. Finally, one may wonder whether Trailers does not introduce a de minimis rule with regards to rules that impede market access. Introducing a de minimis rule was advocated by Advocate General Jacobs years ago in his opinion in Leclerc. Since the market access approach might catch too much of regulation, a threshold criterion was suggested by the Advocate General. Whenever the measure is liable substantially to restrict access to the market, then it would breach Article 34 and would need to be justified. The suggestion of the Advocate General was not followed in the case law. However, in Trailers, as well as in the follow-up case Michelson and Ross, C-142/05, the court noted that the prohibition on the use of a product had a considerable influence on the behavior of the consumers, which, in its turn, affected the access to that product market of the member state. So far, we have discussed the restrictions to free movement of goods prohibited under Articles 34 and 35. The following two slides will give you a brief introduction to the ways in which member states can justify restrictions to free movement of goods. While these have not been the focus of today's lecture, it is important that you study them for the exam. Answering a free movement of goods problem question implies dealing also with matters related to justifications and proportionality. So, what are justifications required for? They are required for discriminatory measures, for product-related rules, as in Cassis de Dijon, or for measures which hinder market access, such as in Commission versus Italy. The available justifications consist of the list provided for in Article 36. Distinctly applicable rules can in principle be justified only by relying on Article 36. However, some exceptions do exist. For example, environmental protection was used to justify a discriminatory measure in Preußen Electra. Mandatory requirements are an open-ended list of justifications developed through case law. As mentioned at the beginning of this lecture, they are used in order to justify indistinctly applicable rules. Once a valid reason was found to justify the restriction to free movement of goods, the court will have to assess proportionality of the measure. The test contains two prongs. The first one is suitability. The national measure must be suitable or appropriate to achieve the aim. The second one is necessity. No other less restrictive means could have been employed in order to achieve the aim of the measure. The degree of scrutiny can vary. Thus, in Rao, the court adopted what is called a strict proportionality review. You will remember that Rao concerned the shape of margarine packages. The court considered that the legislation at stake was designed to prevent butter and margarine from being confused in the mind of the consumer. Therefore, it was appropriate to achieve the protection of the consumer. However, it was not necessary, as the consumers may in fact be protected just as effectively by other measures. for example, by rules on labeling, which hinder the free movement of goods less. Conversely, in dynamic median, the court adopted a soft approach to proportionality. In that case, a company was selling online anime DVDs in Germany. This material had not been examined and classified, as it was required by German child protection legislation. Also, it did not bear any label from a German authority as to the age from which the films could be viewed by children. Therefore, in principle, the material could not have been sold in Germany through online medium. The court retained that child protection might be a suitable justification from banning this product from being sold online. The court noted that the conceptions on child protection may vary from one state to the other, on the basis of moral or cultural views. Member states must thus be recognized as having a definite margin of discretion in this regard. Proportionality in such cases needed thus to be assessed solely by reference to the objectives pursued and the level of protection which the member state in question intended to provide. In another case, Schmidberger, a transport company, challenged a decision authorizing a demonstration on a public motorway as being contrary to Article 34. In this Austrian preliminary reference, the Court of Justice agreed that the closure of the motorway for 30 hours constituted indeed a restriction to free movement of goods. It also noted that this might have been justified on grounds of fundamental rights protection, namely freedom of expression and freedom of assembly. In assessing proportionality, the court engaged in a detailed and sophisticated balancing exercise. It noted that the interests involved must be weighted having regard to all the circumstances in the case, in order to determine whether a fair balance was struck between, on the one hand, the free movement of goods, and on the other, fundamental rights. Several elements were taken into account in that regard, with the court concluding that the Austrian authorities were reasonably entitled to decide that the legitimate objective pursued by the demonstration could not be achieved by measures less restrictive to community trade. I would invite you to read the Schmidberger case and compare it with the Spanish strawberries case that we discussed about at the beginning of this lecture. You will note that the cases, even though they might appear that they relate to fundamental right protection, are completely different one from the other, especially on the point of the proportionality analysis. This is an example of a free movement of goods problem question that might be asked in an examination. There are two aspects to this question. First, we have the obligation to market Bibotal only in glass bottles. This might be qualified as a product rule. According to Dassonville, this is a measure having equivalent effect to quantitative restrictions. The measure is indistinctly applicable as it affects all traders in the same way. Latvia will need to prove a justification for this measure. They will probably rely on the protection of public health. A discussion will need to be made as to whether the measure is proportionate. Is it suitable to achieve the aim? The question is whether it is really dangerous to package alcohol in other containers than glass bottles. Probably the answer to this question is no. Latvia might argue that the measure is justified by the mandatory requirement of consumer protection. Now, given that this is an indistinctly applicable measure, it can be justified following Cassis de Dijon on mandatory requirements. The measure might be suitable to achieve the goal. Say, consumers in Latvia are used that alcohol is always packaged in glass bottles, whereas soft drinks would be packaged in plastic containers. However, it is unlikely that the measure is necessary. Other less restrictive ways can be envisaged for protecting consumers, such as labeling. The second aspect relates to advertising. Following trailers and Scotch whisky, measures that hinder market access are considered by the court as restrictions to free movement of goods. If we follow the trailer's Scotch whisky logic, a restriction on advertising can in principle constitute a market access restriction. Article 34 would thus be infringed unless the measure can be justified by Latvia. You may have noticed that the measure advertising is also a selling arrangement. If we apply KEC, it should fall outside of the scope of Article 34, provided it fulfills the KEC test and the two conditions. And the two conditions are, first, the measure applies to all traders, and second, the measure affects in the same manner in law and in fact the marketing of domestic products and of those from other member states. If the first condition is fulfilled, we know from cases such as the Agostini or Gourmet that the second condition might not be fulfilled. Usually, advertising restrictions make it more difficult for foreign traders to access new markets. And it is Biborova who has to bring proof that the advertising rule does not affect in the same manner the marketing of domestic products and those from other member states. However, we know that the KEC test is rarely fulfilled in practice. Furthermore, on the basis of trailers and Scotch whisky, there are many academics arguing that the KEC test has been overruled. How to proceed then? If you have a problem question concerning selling arrangements in the examination, I would suggest you do exactly as I have done in this sample problem question. That is to say, in a nutshell, first, mention that following trailers and Scotch whisky, market access restrictions fall in the ambit of Article 34. Second, acknowledge that the measure is a selling arrangement which, following KEC, could eventually fall outside Article 34. Discuss the KEC conditions. It is, however, unlikely that those two conditions will be fulfilled in your case. Third, mention that there is an ongoing debate following trailers and Scotch whisky that the KEC case might have been overruled. Mention also that the KEC test is hardly ever fulfilled in practice. Fourth, discuss potential justifications for the measure. Now, on the matter of justifications, we have to come back to our case. Because if it is found that the measure falls within the ambit of Article 34, Latvia would need to justify it. Again, given this is an indistinctly applicable measure in law, Latvia can use the mandatory requirement of consumer protection. They could also argue that the grounds of public policy require a serious fight against alcoholism. The measure looks suitable to the aim pursued. With regards to necessity, one would need to assess whether other less restrictive means would be available. We face here a partial ban on advertising, thus potentially the court would consider the measure to be justified. Thank you very much for your attention. I look forward to discuss these issues further with you on the online forum. Please do not hesitate to contribute with an answer to the questions raised on the forum. Feel free to ask your own questions and raise clarification points. The final two slides will sum up what has been discussed so far, including a mind map on how to solve a free movement of goods case.